Aloha. We are live from the floor of the Hawaii Tax Institute in Honolulu, Hawaii. We are very fortunate to have one of the great speakers at the Hawaii Tax Conference, Steve Trytten, who recently joined forces with the law firm of Henderson, Caverly, Pum, and Trytten, which is based out of San Diego, but Steve heads up their efforts in Los Angeles.
So let's talk about qualified plans or IRA as an asset. As an estate planner, they're terrific while person's alive and defer taxes, but it's a very unwieldy asset to gift away or do any estate planning with. And for a lot of clients, that tends to be their major asset, is their qualified plan. Talk to us about some strategies that you employ to facilitate a more tax efficient transfer of this asset.
No question that retirement plans and IRAs need more tender loving care to become part of the estate plan, but there's so much potential benefit, at least under current law, if a parent can leave an IRA or retirement plan to a child, it will probably be worth twice as much, maybe more, net of all taxes and costs. And if they can leave a Roth IRA, at least 4 times as much. You just have to be committed to paying attention to the details, both as a client and as an advisor, because there are several details that have to be watched.
And what might those be?
Clients have a tendency to think, okay, I've signed my will, I've signed my trust, my estate plan is set. Next week they go down to the financial house and they're given a death beneficiary designation and they don't realize that's another will. They don't think in those terms.
Right.
Or they move an account from one place to another and they get to the new place and they say, how should I fill this out? And somebody there says, oh, name your estate or name your revocable trust, and then the whole thing is wrong. You need a team of advisors that works together, and you've got to think of it as developing long-term relationships and not just a transaction-by-transaction process, because it's so complicated. And that is the best way that we could keep these beneficiary designations from going sideways, is if the financial advisor knows the game plan.
Can you talk to us about why using a trust as the beneficiary of an IRA is a preferred method for some people?
The use of trusts with IRAs and retirement plans is a really important topic. And a lot of estate planners shy away from these trusts because they're so complicated. But if you go back to this fundamental rule of, I'm going to ask my client without even getting into tax or technical issues, what do you want? A lot of clients are going to say, well, I think my children need trusts. I don't think I want all this money falling in their lap. So I like to figure out whether we need a trust before we even get to discussing the retirement plan.
So you can talk about the use of trust in terms of helping to preserve a legacy asset for future generations.
Trust can be a great tool to carry out the client's vision, which sometimes means keeping things in the family line or limiting what you might call the drainage or the drift. You can accomplish that with trusts for the most part. Depending on how you draft it, you can make them a little stronger, which probably means you've got an independent trustee and not a family member. And then even then, the execution of the trust, heaven forbid that situation where you have the son and the daughter-in-law and you're wanting to protect for the children of that marriage, and then a divorce comes up. Those trusts are not bulletproof when that son goes through a divorce. And the more that couple relied on the trust as part of their day-to-day finances, the more vulnerable that trust is.
Any last advice you would give in a call to action to your advisors, clients, or family members who are dealing with these issues?
I would say don't shy away from spending some time on the retirement plans and IRAs, because there's a really good payoff available. These retirements and IRAs, they don't just take care of themselves. They get hung up, they can go to the wrong people, or they can flunk the minimum requirements to even get deferral. So you win if you get it all right, and you lose if you miss anything. So pay attention.